All right, so we're at day 72 of the Blake Lively Justin Baldoni lawsuit filed in the Southern District of New York to federal court. And there's a lot that's happened in 72
Yeah,
days.
there has. I know we were just talking about that. There's been like a lightning fast court case. It doesn't normally happen this way, but
I mean, most of our cases, Keith, are a year and a half to 5 years. And so for all of these motions to be heard, the filings to be made, we have supplemental filings or amended filings being made. There's just a lot going on here.
yeah, it's happening fast and furious. And here we are Thursday. I think the oral hearing by the court was last Friday. And here we are.
Thursday, I think.
Was it Thursday?
Yeah.
So about a week later, and we have the court's order on the protective order. Now we know what the court's going to do.
So Judge Liman, he posts an order on this issue of the protective order. And if you could just set up for us, Lively had some arguments about whether they wanted the protective order or not. And Baldoni had some arguments about whether he wanted the protective order or not. Can you just set that up again before we get to Judge Lyman's order?
Yeah, because it's actually both sides wanted a protective order, and they both wanted to be able to mark documents as confidential, which means that they would be shared with the attorneys and with the parties, right? Because that's how that works. And then they could use it with witnesses, but they couldn't disclose it publicly. So no dispute there.
Let's take one step back further, though, Keith. I mean, so you got somebody that, in both people in this case, they want documents from the other side, right?
That's right.
Because you win documents by the facts, the witnesses, and the documents in a case.
You win
right?
trials that way. Yes.
I'm sorry.
Yeah.
What did I say?
You said you win documents.
You can win documents too.
Yeah.
So you win trials by establishing the facts.
Yeah.
And you do that through witnesses and documents.
Yes.
And so what you do is you want documents from the other side.
That's right.
And in federal courts, there's mandatory disclosure of documents. In state court, we fight over what documents have to be given. But ultimately, both sides want documents from each other.
Yeah.
And they want invasive documents. They want documents that you don't want to produce to the other side. And so there's this argument about, well, can we protect some of these documents because there's famous people involved here, there's sensitive information, that kind of stuff, right?
Yeah, there's medical information, there's trade secret information, all the sensitive information that you wouldn't want to get out publicly, especially on a highly publicized case.
And so what was Blake Lively's view of should there be a protective order in place regarding the documents that she has to turn over to Justin Baldoni?
Yeah, not only did she want a protective order, but she wanted the right to unilaterally designate documents as attorney's eyes only. And that's a higher designation than confidential, because what it means is only the attorneys could see those documents, not the parties. And she wanted to be able, her attorneys wanted to be able to designate documents as attorney's eyes only unilaterally, so they could decide what gets the attorney's eyes only stamp.
So let me walk through that. Let's say that Blake Lively's attorneys have a text message that they don't want to turn over to Justin Baldoni and his crew because they're afraid that somebody over there, and when we talk about parties, Justin Baldoni's a party, Wayfair is a party, Steve Sarowitz is a party. What Lively's saying is the desire to disclose this or leak it to the press is so strong that Baldoni won't be able to resist this urge. And so we want to take this text messages that we believe should be attorney's eyes only. We want to make that determination for ourselves. Blake Lively's attorneys want to make that themselves. They want to stamp it attorney's eyes only.
That's right.
And that means only the lawyers for Justin Baldoni can look at it. But Justin Baldoni and everybody else that's being represented by the lawyers, they can't look at it. Is that how that works?
Yeah, that's how that works. And you can imagine what a problem that is, because as a lawyer, we need to show evidence and information to our client. We want to show them good things. We want to show them bad things. And it helps to develop the case. It helps them develop their claims and their defenses. And it helps in formulating settlements and settlement positions. And so it really ties the attorney's hands when you can't show your client documents.
So the attorney's eyes only designation, that was important to Blake Lively and her crew. And there was this model order that the federal court, Judge Liman at his court, he has a model order that anybody can just pull off the shelf and use. And he's done a billion protective orders. So he says, this is the best protective order that I like as a judge, that I like to see the parties use in a case going forward. But there were changes that Blake Lively's team wanted to that model order. They wanted to add additional terms for this attorney's eyes only designation. Is that how that worked?
Yeah. So they wanted to have this whole category where they could unilaterally stamp something attorney's eyes only, and then it would automatically apply and only the attorneys could see it. Now on Baldoni's side, he said, look, the model order is fine because it actually provides for an attorney's eyes only designation if, and this is the big distinction, if the parties come together and agree on it. But you can't just do it unilaterally. And that was what the fight was over.
So Blake Lively, her team wanted to have a rubber stamp that said attorney's eyes only, and they wanted to use it in their discretion on any document they wanted.
Yeah.
And that presumably would make it an attorney's eyes only or attorney's eyes only designation, unless Baldoni's lawyers went to the federal court and said, hey, we don't think this AEO designation is appropriate. And so it makes a big fight over all the documents.
Right.
And so if you were Lively's attorneys, you just have that rubber stamp and you're just stamping everything attorney's eyes only.
Well, yeah. And the problem, attorneys are conservative creatures. And so you're going to overuse it. You just are. I mean, it doesn't even need to be nefarious. You're just going to be, out of an abundance of caution, you're going to be stamping more than you're not stamping.
And just before we get into Judge Liman's order, which you have fully sliced and diced and reviewed, and you're ready to walk through that, there is also this idea of marking documents in discovery confidential under a protective order. And, so the model order here did have a provision that allowed the parties to mark documents on either side confidential.
Yeah.
What's the big distinction between marking a document confidential and marking it attorney's eyes only?
The parties can see it or the parties can't see it. So when you mark it confidential, the parties get a look at
Justin Baldoni and the actual clients of Brian Freeman, they can actually look at these documents as they come in from Blake Lively.
Yeah, everybody who's designated as a party on either side can look at these documents. When it's attorney's eyes only, they cannot. Only the attorneys can see it.
Okay, and you can see that, obviously there can get a lot of games get played here. And then there's accusations that documents that were marked as attorney's eyes only were given to improper people. And so it really causes an uproar. Well, there was a filing by Blake Lively. There was a filing by Justin Baldoni. The court looked at both their filings on this issue of the protective order. And now today, Judge Liman has made a ruling. And if you could walk us through, what was your analysis of Judge Liman's order?
So let's go to page 2, and here it is in a nutshell, and it's the kind of small paragraph down there. Yeah, so the court says, for the following reasons, the moving parties, remember the moving parties on this motion was Lively, the moving parties' motion for entry of a protective order is granted in part and denied in part. So he's going to give everybody a little something here. The way I read this, I think that Baldoni won more than he lost. I think that the judge cut back Lively's arguments substantially, but he did give them something on the attorney's eyes only issue, and we'll look at that. But essentially, he gave them attorney's eyes only designation on 4 categories of documents.
Okay, so just so I'm clear on this, you're saying that Baldoni mostly wins this because they don't. Blake Lively's attorneys don't get the unilateral use of the attorney's eyes only stamp on any and all documents.
Yeah.
But there's going to be 4 categories of documents that they can use the attorney's eyes only designation.
Yeah, and they can use it unilaterally on these 4 categories, but not just everything.
And Baldoni can, under these same categories, it goes both ways, right?
Absolutely, yeah. Goes both ways.
All right.
So let's go down to page, what do we have here? Page 5, yeah. And so what we're looking at here. So the moving parties have shown good cause for a limited attorney's eyes only. I'm going to mess this up if I say AEO because I'm going to transpose it, but AEO is attorney's eyes only. So the moving parties have shown good cause for a limited attorney's eyes only provision and have shown that entering such a provision now is critical to the just and speedy, if not necessarily inexpensive, determination of the case. So I guess the judge is saying it's probably good for now that we do this, even though it might make it more expensive to handle the case.
Okay.
So that's essentially what we're looking at. And then we'll go to page 7. And on the top of page 7, we're going to see the first category. So here's the first category of documents that can be protected with the attorney's eyes only, and that's trade secret information. So the disclosure of trade secret information in the form of business and marketing plans for projects other than, it ends with us, to a competitor who would have the ability to use that information to further its own business interests poses an incremental says risk of inevitable disclosure and use, I think it means risk. I think that's a typo, risk of inevitable disclosure. So if you're talking about anything that has to do with business and marketing plans of it ends with us, you cannot designate that attorney's eyes only. Why? Because it's relevant to the case,
Right.
directly relevant to the case. But if you're talking about other business and marketing plans, that you could designate as attorney's eyes only.
And I would think, Keith, this first category of trade secret information, this is kind of a no-brainer. This is a public case. People know it. If there is truly trade secret information out there, I think most federal courts, most state courts are going to say attorney's eyes only designation on this type of stuff, not a problem.
Yeah, this is what attorney's eyes only is typically used for. So there's really kind of no surprise there. I did like the fact, though, that the judge carved out it ends with us from this because it is directly relevant. So I think that probably in the judge's mind and in my mind too, I think it prevents gamesmanship with things that are directly relevant to the case. So I applaud the judge for doing that.
Before we move on to the next category, there is a footnote at the bottom here, and Judge Liman says, to be clear, business and marketing plans regarding it ends with us cannot be designated AEO given the central relevance of such information to this case. And that's what you were just saying.
Yeah, boom, there you have it. And I applaud the judge for doing that. It's going to avoid gamesmanship, I think, on that issue.
Okay, was there a second category?
Yeah, at the bottom of page 7 here, we have our second category. This is information that can be designated attorney's eyes only, and it's the medical records of parties or third parties also may properly be marked attorney's eyes only, albeit for somewhat different reasons. In other words, the reasoning why this would be marked that way is not because we're afraid of people using it for their own gain the way trade secrets could be, but rather because it's sensitive and private information.
So, for example, if any of the stars here had any type of cosmetic surgery or something like that, they wouldn't want that to get out. They wouldn't want their regular medical records to get out, but they certainly wouldn't want cosmetic surgery and stuff like that. So if there is somebody had a tummy tuck or a facelift or a nose job or whatever it is, that qualifies as a medical record, and we don't want the parties of either side seeing any of that, and the lawyers are the only ones that can look at this.
Yeah, and keep in mind, think about why the judge likes attorney eyes only, because attorneys are officers of the court, and it's much easier for the court to do a punishment on an attorney versus a party. As officers of the court, they just have more ability to control attorneys and mete out punishments if it's intentionally violated. And so that's why they feel more comfortable with it.
I agree with that 100%. But I also think that Blake Lively's team had argued that if Judge Liman was to order the parties, Justin Baldoni et al., not to disclose this information, that the urge to disclose this information was just too strong.
Yeah.
And I don't think that was a great argument, because I think Judge Liman is a federal district court judge. I mean, it's a powerful position. I think there's 1,100 people in the country that are federal district court judges, and he can punish people severely.
Yeah.
Not physically, but through the
there's no caning.
Yeah,
happening,
there's no caning happening.
Right.
No spankings.
Yeah.
But he could certainly strike their answer.
Yeah.
He could tell the jury not to believe them for a certain reason, or he could do all kinds of things if somebody violates one of his orders.
Think about that for a minute too, because what does it mean to strike somebody's answer?
They have no defense.
They lose by default.
Yes.
Without a trial.
Right.
I mean, that's pretty powerful.
Yes. Yeah. So I think, but again, so far, I haven't disagreed with anything in Judge Liman's order here. I think trade secret, that's exactly what AEO is for. And now medical records, yeah, I mean, this is a public case. I think in any case, medical records I don't want my medical records to be seen by anybody, but I certainly wouldn't want, if I was suing somebody, I wouldn't want them to see it. So if their lawyer gets to see it, that's okay with me.
And that's not to say that this will always be attorney's eyes only. So the parties have the right to go in and say, Your Honor, it's important that the client see this information, and the judge can allow that. But this is just the beginning point. This is the starting point.
All right. Anything else?
Yeah, let's go to the number 3 here, and we'll drop down. We're on page 8. And the first full paragraph there that starts with another AEO category in the protective order is security measures taken by parties or third parties. So there was an argument that, there's certain security measures that celebrities take, and to disclose that could harm the people who are taking these securities measures. The judge points out that, look, the Wayfarer parties have suggested that security measures are not relevant to this proceeding, but they have not raised objections to such information being kept AEO if it is disclosed. So it's kind of like the judge is thinking, well, they didn't say we couldn't, and they didn't argue against it. So let's just put attorney's eyes only on that.
And I would say this is just out of an abundance of caution. I mean, this is the first one I'm looking at where I'm going, okay, what security measures are you talking about? You know, where you sleep at night? You know, how are you when you go to a restaurant? How many people go with you? I don't know exactly what we're talking about here, but I think the judge, out of an abundance of caution, is saying, look, if there's security measures and you can clearly see this is for protecting somebody or making them safe, you can't disclose that because somebody, a reporter or somebody from TMZ, somebody could interpret this information and understand it, and maybe
harm somebody.
Next thing you know, you're sitting by Ryan Reynolds having a conversation with him that he's not all that happy about. So,
right. Well, I don't think I'll be doing that, but yeah, that could happen. And it's probably not directly relevant to the case, is what the judge is also thinking. But again, these are not set in stone. The judge can allow exceptions going forward.
Let's talk about that for a second. So a lot of times when we go to trial, Keith, we meet with the judge, and the judge makes rulings at the beginning of a trial. The jury's not there. They can't see any of this. And so we're talking with the judge, and we're going over jury instructions, and we're going over orders of the court and so forth. And every good judge I've been in front of always says, look, this is my order now, guys.
Right.
But come middle of the trial, if you really think you need to use a piece of evidence, let's move the jury back to the room where they're away from us, and we can all talk about whether this is something that comes in or not. And I think that's what Judge Liman is saying in this order. He's giving these 4 categories that are going to be allowed to be attorney's eyes only. But not only that, just because somebody marks something AEO, that's something that Brian Friedman and Baldoni or any of the parties in this case could bring to the judge and say, I don't think that's a proper designation.
Oh, sure.
And I think the court should remove that AEO designation.
Absolutely. Yeah. And that's why the judge has the ability to vary these things. And I think, again, let's talk about the 4th one. But I think what we're seeing here is, by and large, Baldoni won this argument because it's not just a free-for-all the way that the lively parties wanted it. So the 4th category is this last paragraph on page 8. And by the judge's own admission, he says the most challenging AEO category is highly personal and intimate information about third parties and highly personal and intimate information about parties. So he's saying, well, look, this is the most troubling one. And you could see why, because what does that mean? I mean, saying you could designate highly personal and intimate information. I mean, I could make an argument that all sorts of things are highly personal and intimate. And so the judge struggled with this one. By his own admission, even says that right there. And so let's go down towards the end of this paragraph where it says some information of a personal and intimate nature regarding the parties will inevitably have to be shared with persons other than the attorneys. The parties who are making the accusations or who are the subject of the accusations have a right to participate in the prosecution and defense of the claims. The attorneys have a need to consult with their clients. Okay, well, that is the problem, isn't it? But let's drop down to page 9. In the first part of the top of that paragraph, the judge, having said that, goes on by saying, however, it is in the nature of discovery that the net will be cast wide and each side will be forced to disclose to the other information of a sensitive, personal, and intimate nature that is not necessary or even relevant to the prosecution or defense of the claims. So the point is even more apparent with respect to non-parties. So in other words, at this point in the case, when we're beginning the discovery process, everybody's going to be casting a wide net, which is what we do in discovery. And so the judge is concerned about that. He's concerned about this wide net. And then let's drop down in this same paragraph, because there is a limitation on this. So the judge didn't just give him, free rein here. And so the judge said, before the parties make an AEO designation, the protective order places on that party the burden of determining that the information is not directly relevant to an allegation in the pleadings. Okay, now for the non-parties, no such burden is appropriate. So for non-parties, okay, you can go ahead and protect all of this personal and intimate information. But for a party, the attorneys first have to make sure that whatever they are trying to protect under AEO, it's not directly relevant to this case.
So overall, you've taken a look at this order, and is it a fair order? Is it an unfair order? How easy or hard is it going to be to follow? What are your thoughts?
I think it is. I mean, I think the judge did what I I think I predicted what the judge would do, which is he's going to not allow an open-ended AEO designation by Lively, but he was going to protect certain categories. And I think you could see that coming. And it makes sense. Like you said, the trade secret, that's what we use protective orders for. Medical records. Okay, let's play it safe. We'll protect those. The security measures, that's kind of a giveaway because he says, well, Wayfair didn't really object to it. The personal and intimate, that's going to be where the fight's going to be.
And it's very subjective determination of what that even means.
So subjective. Yeah. And it's really going to be a tricky one. And can you pull up the actual protective order on page 2? And I'll show you the language in the protective order and why this is going to be a little problematic. So we've highlighted here these are the 4 areas where you can
So let's be clear, is that coming right from the judge's protective order?
Yeah, this is the actual protective. So we were just looking at the reasoning, the memorandum the court used, but this is the actual protective order that the court is instituting. And of course you have A, trade secrets, B, security measures, C, medical information, but look at D, highly personal and intimate information about third parties and highly personal and intimate information about parties other than information directly relevant to the truth or falsity of any allegation in the complaints in this case. Okay, that's where the fight's going to be. I mean, somebody's going to designate something as attorney's eyes only, and the other side's going to say, wait a minute, that's directly relevant. So you're going to see more coming, I think, on that sub D element there.
Okay. So, I mean, at the end of the day here, if we're looking at Baldoni's camp and Lively's camp, they're back, they're huddled, they're going over this protective order. Do both sides feel good? Do both sides feel bad? What are your thoughts on that?
If I was on the Baldoni side, I'd feel pretty good. I'd feel like, wow, we got almost everything we wanted. I mean, yes, we have, a few things that are attorney's eyes only, but we stopped the Lively attorneys from being able to unilaterally designate anything and everything. And we now have some grounds where we can push back on them if they over designate things, such as designating highly personal information that is relevant to the case. So I'm feeling pretty good on the Baldoni side. I think he mostly won. I think on the Lively side, I think that they probably feel like they didn't win. If I was on the Lively side, I'm like, well, we got a few things, but it isn't really what we wanted. How would you feel on both sides?
I think both sides can take away from this that they got something that they wanted. I do think Baldoni got the better of this, but I still think Blake Lively's team wanted the ability to protect some information. And they appeared at the argument to point out that there's a lot of famous people involved in this case, and they didn't want to disclose addresses and things like that. Of course, all that stuff is redacted, and no judge is going to require you to point out where all the famous people, where they're. I mean, you can Google where most of these people live, but you don't want this in it. You don't want their phone numbers, their cell phone numbers. I know when I was a younger lawyer and I would take a lot of depositions. I still take a few depositions, but when I was very young, I took everything that came in the door. We would have lawyers on the other side ask right there in deposition for my client's social security number. And, right. And I would just simply say, no, you're not getting it. And they literally would fight with me over that. And then they would ask, what's the address of your client? Well, that's an appropriate question to ask of somebody that's not famous. And so, yeah, you can ask what their address is. I mean, in fact, there's form discovery that allows for that. Other questions that we get, you and I have handled cases. I think one particular where there was a hip hop mogul that got a minor pregnant when she was 15 years old.
Yeah, that was terrible.
And of course, now she's 30, and he didn't follow through with some promises that he made to her. So we had to end up suing on that case. But they hired a high-end defense attorney, bit of a bulldog, and she comes in, and so she asked my client, "Did you have sex with the hip hop mogul?" And I thought, well, I'm going to let her ask that once, because clearly there's a child, there's offspring, there's DNA to show that this person came from the hip hop mogul. And so but then she wanted to know, well, how many times did you have sex? And where did you have sex? And I just basically told the lawyer, you're not, next question. She said, I'm going to drag you in front of the judge. And I said, I hope you do drag me in front of a judge, because I want to know what your argument is as to why you need to know how many times my client had sex with somebody when she clearly has a DNA test showing. So defense attorneys and plaintiffs' lawyers too, let's be fair, they're going to take the rules and they're going to try to leverage them. And then, of course, they're going to try to hoodwink the other side to some degree. I mean, think about going into depositions where you've got attorney's eyes only designations. Think about all the phone calls you're going to be having between the lawyers and saying, I don't think you properly designated this. I'm going to drag you in front of the judge. And that's going to extend out this deposition that we're supposed to have done by August.
I'm going to need a continuance because we got to figure this out.
We've got to figure it out. So there's a lot of games that can be played here.
What about let's just say that there's text messages between Lively and Taylor Swift. And some of them are just, general things that people text to each other. But some of them they're talking about, it ends with us.
Mm-hmm.
What's going to be designated attorney's eyes only and what isn't under this scenario?
Well, to me, that would be directly relevant to this case.
If they're talking about it ends with us.
If they're talking about it ends with us. And so I think that's within the scope of discovery. And I think that comes in. Now, if there's let's say that Taylor Swift says, hey, meet me at my private house that nobody knows about. TMZ can't find me there.
Yeah.
And here's the address, 123 Main Street. I think that you're going to be able to not only designate that as attorney's eyes only, I think you could redact that address and you would get away with that.
What if it says that and then below it says, I want to talk to you about Baldoni and what a creep he is?
I think that comes in.
So, but you could redact the address part,
right?
But keep the second part.
Sometimes when you're redacting, you slip.
Yeah, that's the problem.
And you redact too much.
Yeah.
And then it's hard to undo it. But no, yeah. I mean, no, in all seriousness, you have to turn over anything that's relevant to the case. By the way, that's a good point. If you, as a lawyer, want to lose your ability to practice law, do that kind of stuff.
Play those kind of games with the federal judge.
With the federal judge.
Right.
Yeah. So don't be making mistakes like that.
What if the text doesn't directly come out and say anything about Baldoni, but it insinuates something? I'm dealing with this guy that has a man bun that I can't stand. I'm really going to try and take over. It just says that. Is it directly relevant or is it not?
That's a tweener.
Yeah.
Because there's lots of people that wear man buns, but we know that Justin Baldoni is a well-known man bun. He wears it. So I think you have to, that's one where I might even ask the court to do an in-camera review if it's willing to do it and say, do we have to, or just mark it attorney's eyes only and get it to the other side and get their input. And by the way, lawyers don't pick up the phone and call each other enough.
Right.
Everybody wants to fight and pound their chest. Pick up the phone if you can and call and say, hey, I've got this issue. I want to disclose to you what you're entitled to, but I have this issue and I'm not sure if I just can disclose this. Can I mark it attorney's eyes only? Let you guys look at it, get your comments back, and let's see where we go from there.
But that's where you're going to run into the problems is on the tweeners. Those are going to be the hard ones. And if you don't have attorneys who are picking up the phone, or the other problem you run into sometimes is you pick up the phone and for whatever reason, the other attorney's just stubborn. There's no give and take. There's no discussion. It's just like, nope, this is the way it is. Okay, we got to go to court. Let the judge decide. So I can see that this D prong with the highly sensitive information, it's going to be rife for argument if they're not careful.
What if there's a text message, and I want to take Taylor Swift out of this, but let's say that there's an A-list celebrity and there's a text message that arguably could apply to Baldoni, but it may not. And it talks about some type of sexual activity.
Right.
What do you do with that?
Yeah. Again, it's a tweener. Is it directly relevant to this case or is it not? And it's, I think, again, I would do what you would do, which is mark it as attorney's eyes only, pick up the phone and say, hey, I've got these documents. I'm marking them attorney's eyes only for now. Let's talk about them. I'm not sure that they're directly relevant, but if you think that they are, let's hear your reason why, and let's see if we can have some give and take. But again, that takes reasonable people having reasonable discussions, which, doesn't always happen in our world.
Another thing, Keith, with the attorney's eyes only designation and confidential designations, let's say, and this happens in more cases than people probably realize, let's say out of the, let's call it 500,000 documents that are being exchanged, what if there's one document that's accidentally, inadvertently disclosed and it doesn't have any designation on it, no attorney's eyes only, no confidentiality, but it clearly is a trade secret, or it clearly is a security measure or medical information or something of such a highly personal nature? What would be the obligation on the law firm that receives that document? Since it's not marked as attorney's eyes only, it's not marked as confidential, it slipped through, it clearly is an inadvertent production. what can the attorney that gets that document do? Can they run to TMZ or the press and say, hey, I've got this, look at this very embarrassing information?
No, I mean, they're going to be in a world of hurt in front of the judge if they do that. And it's kind of like what happens when there's inadvertent disclosure of attorney-client privilege information. What your obligation is as an attorney, if the other side gives you something and you start reading it and you can pick up on the fact of, oh, this is an email between the client and the attorney, I should not be reading this.
Do you finish reading it and,
no,
then delete it?
No, you immediately stop, you delete it, and you notify the other side and you say, there's been this inadvertent disclosure. Now, if you think that there's a reason why you should get that document because it was disclosed to somebody, there's some reason it was disclosed to a third party, it destroyed the privilege, fine. You go to court on your motion and you ask the judge to order that. But you don't just read attorney-client privilege information that's inadvertently produced, because you have, as a lawyer, you have an ethical obligation not to do that. I think the same would apply here, and I don't think the judge would be very appreciative of you getting information that clearly was a medical record that should have been marked confidential in attorney's eyes only and was, mistakenly not. I think you have an obligation to stop right there, hand it back to the other side and say, hey, you might want to look at this document. You tell me, is it?
And I've deleted it from my system.
I've deleted it from my system, and I want you to produce it back to me.
I want to talk to our jury pool just for a second, and I want you to envision that you get this juicy piece of information that is clearly protected. Let's say it's an attorney-client privilege. Let's say it's between Blake Lively and her lawyers, and they're giving her 5 paragraphs of advice on how to resolve this case. And you're reading that, and you're a lawyer, you're reading that, and you realize through the first 2 lines that you're reading a document from a lawyer to Blake Lively. But there's more to read, and it's right there in front of you. You can just keep reading. It's really good information for your case. Would you have the self-discipline to stop reading, number one, and number 2, immediately contact the other side and say, hey, I think you made an inadvertent disclosure, and by the way, I've deleted it. I've deleted it from my system, and I want you to take a look at it and let me know if you meant to give that to me. If you meant to give it to me, send it back, because I'd like to look at it. But you and I both have had times in our career, it's a few times, it's just a handful, where we've been reading an email and we've understood through the first 3 lines, this is something I should not be reading. And the discipline it takes to stop is immense. It is so difficult, because as much as, think about the jury pool, how much do you guys care about this case? You guys are actually following this case day in and day out. You know all the facts. Here you've got this juicy piece of information that nobody else has. It's one of the hardest things you have to do as a lawyer.
It really is, yeah. But you have to do it. I mean, the number one reason, obviously, is because you have an ethical duty as a lawyer to do that. That's the first point. But the second, maybe more important point, is that if I, as a lawyer, if I don't help protect the ethics of this profession, then it ceases to be a profession.
Yeah.
And people stop trusting it. Now, look, we all know that there's lawyers out there who freely violate ethical rules, unfortunately. But a vast majority of lawyers don't do that, and they don't want to do that, because we feel an immense amount of, pride, but also responsibility to make sure that we live up to those duties. I mean, we're given a special position in society, but there's a trade-off for that. You have to live up to those duties. And quite frankly, you get farther in court when you do it too, because judges do not appreciate when you violate those rules either. And so if you just start using this information, the judge finds out about it, you're going to be in big trouble. So, I mean, that's, I guess, a third lesser reason in my mind, but it is a third reason why you would do it. Yeah,
it is unfortunate there are stories like Michael Avenatti, the lawyer from California, and then there's Tom Girardi, and unfortunately people hear about that, stealing from clients.
Oh, those are bombastic cases.
Yeah, and I do think the majority of lawyers, and I think the lawyers in this case that I've looked at, I've had a really good time reading the backgrounds on the lawyers that are on Baldoni's team, the background of the lawyers on Lively's team. These all are very well-respected lawyers. They're all very bright. They're smart. They all have a different game to play, because some people have better evidence, some people may not have good evidence. And so that's what lawyering is, though. That's the hard part of lawyering, is figuring out, how do I get this case from where it is now to where I want it to be? And of course, you've got the opposing side trying to keep you from executing your plan. Sometimes the judge stops you from executing your plan. And so those are issues that you have to think about. I remember when I was a young lawyer, I had an older, wise lawyer tell me that being a lawyer, let me explain it to you. It's like being a surgeon, and the first time you're taking out somebody's appendix from an appendicitis. but there's another surgeon there and they're trying to stop you from taking out that appendix.
There's like a competing scalpel.
You're scalpel fighting at some point.
Yeah. It is an odd profession in that regard. Yeah. And it is, I mean, we're in a high conflict profession too. I mean, it's not, it's most professions, you don't get called names and yelled at like we do. And so you kind of get used to it over time. And so it's not as big of a deal, but it is interesting.
Yeah. So before we go, I don't know if producer Eric is still with us. And if he is, I don't know if there was any questions from the live stream that we wanted to jump on.
He is not in studio. He's remote. So we can't hear the voice of Eric, the beautiful voice of Eric through our headphones.
Okay.
I did want to point out though, some people wanted us, and I'm going to mess this up guys, because I don't know the right term for this, but they wanted us to have something where people in the comments would have a badge, or I forget what it is. And obviously, we have day jobs and we do well as attorneys. And so what the thought was is we were going to go ahead and create the badge so people could sign up for that. But we wanted to give that money to charity. And I think Eric actually did he did a survey. Eric, can you join us? Just join us on screen for a minute. We want to see your face. Everybody wants to see what producer Eric looks like. There. Oh
my gosh! Look at producer Eric.
Oh, you're muted. Okay.
He's gonna fix it.
It's surprise.
No, we still can't hear you. That's okay.
Okay, here we go.
There we are. Look at that voice made for radio and television. My gosh.
Thanks. So I put it up in our YouTube, and I put in these comments here, but there's a poll on our page, and people can decide, where they want our money to go to in the charities. Go on our page and you can vote. The options right now are helping families in need and access to justice and legal aid, medical and health research and aid, and animal welfare. That's what we got so far, but we're open to anything. Here, I'll put a couple people appreciating your guys' breakdowns. Here was another question. What if one of my other personalities decides to continue to read this information?
Yeah, right.
That was a good one.
Yeah. That's when you have the little angel and the little devil on your shoulder.
Yeah. I know. This is the one day I wasn't in studio with you guys, of course.
That's all right.
You
still do. You take care of us from wherever you are. We appreciate it. Thanks. And now people get to see the voice, so that's good.
Yeah, I wanted to keep
remain
putting
anonymous
it off for a longer time. I want to upstage you guys while I'm at home in my glasses and hoodie, but yeah.
Well, I'm glad everybody could see you. Eric's the person who makes the magic happen, and we wouldn't be able to do any of this without him. So really appreciate all the work you do for us, Eric. It's fantastic.
Yeah.
Oh, thanks, guys. So I'm proud of you guys, and we're so happy to have everyone included, and have all these viewers and stuff. It's been a cool community to be a part of, and we're excited to keep growing. I got a lot of ideas. I'm talked to you about it, Keith, yesterday, but I'm gonna make you guys do more work for our audience. But we got some ideas and hopefully some things that everyone will be excited about coming soon.
And then what are we doing tomorrow?
So you guys are on Zach Peters' show, 8:30 a.m. Pacific. And then do we want to stream later in the day too?
Yeah, well, we'll see what if anything else is filed too, anything else that we can bring to the table and hopefully add some value on this case. But it's been fun covering it, and obviously we're very steeped in the facts at this point.
We are, and I do want to say that we really do appreciate the comments. We're calling everybody the jury pool. We don't know if that sticks or not, but jury pool are the people that are taking the time to actually figure out the facts of this case. We've learned a lot about. We still don't know about the subpoena, what subpoena was used to get the documents that were given to the New York Times.
Yeah.
So I think a lot of people on YouTube, a lot of people are trying to figure that out.
Yeah.
We're being told various stories from people, but I do appreciate every single one of you out there to take the time to listen to what we have to say. We didn't even know people wanted to listen to us, quite frankly. Keith and I drive down the road, and this is what we actually do.
Yeah, we just have conversations.
When we're driving down the road, it's all this gibberish. So we just thought, well, if people want to watch us on YouTube do this, I suppose we can do it. But thank you so much for your input, your questions, your comments, your directives to us, helping us figure out what we can do to be better. This is a really exciting case. And obviously, Keith and I aren't so comfortable with, the National Enquirer, TMZ kind of stuff that's going on here. What we're more interested in is educating people on how the federal district court system works, how the rules of evidence work, how discovery works. So we're taking a very interesting issue to many people. It's interesting to us too, but we normally wouldn't pay attention to this, but we're hoping that people can learn a little bit more about our system and how it works.
Yeah. And I think we're learning too. It's always fun to see good lawyering back and forth. And you always pick up a couple tidbits that's helpful in our own practice and just our own thoughts and everything. So really good lawyering on both sides in terms of just the drafting. I don't know about the arguments necessarily in court. I guess there was some problems on Lively's side with the court arguments, but overall, as far as this protective order, I'm going to give the win to Baldoni.
And I think the judge did a good job with this too.
Yeah, he did.
I think Judge Liman, he pulled this all together and did a very nice job. I do think that final category, subsection D, the highly personal and intimate information, that's going to cause some fights. But again, that we'll be able to comment on it, and people will be able to give their comments as well.
Oh, it's going to be good for us.
Yeah,
definitely good for us.
Yeah. So, all right. Well, we'll jump on again tomorrow. If anything earth-shattering happens again, we'll be on Zach Peter tomorrow morning, Pacific time. He's a good guy, and he's always interesting to talk with about this case. He has some insights on this case that some others do not. So yeah, he's a good guy. So look forward to doing that tomorrow, and we'll see you all maybe tomorrow as well, afternoon.
Sounds good. We'll see you then.
Bye.
Bye, everyone.